how do you figure out what the boundaries of a patent are? The patent office examiner is going to say, I'm going to assume that this is as broad as can reasonably be read. The reason I do that as the examiner is that if it's that broad, then it's probably not going to be patentable. It's going to overlap with other things, other people's prior property rights. Okay, and that means it can't be granted as a patent. By assuming that, I'm forcing the applicant to amend their claims, change the language, narrow it a little bit. Now, you can do that in application and examination stages because the patent applicant has the ability to revise their claims. They can change what the boundaries actually are because we haven't pinned down the legal right yet. Once the patent has been granted, it has a meaning, it has a scope, and courts will respect that. I think you could break down what lawyers and economists would call patent quality. It's a very loaded term. It means a lot of different things to different people. But I think we could reasonably agree that quality consists of three things. One is technological quality. If it's not useful, if it's not really new compared to what came before, or if somebody tinkering in their garage could have come up with it over a weekend, then maybe it's not really of high technological quality. The second kind of quality is economic quality. A patent is essentially an economic right. When you have one, you can stop other people from entering the market, right? You can clear the market and then you can charge whatever you want, you can recoup your investment. That's the idea. If a patent is written in such a way that it doesn't cover very much, and you can sort of invent around it or produce a competing product that doesn't infringe the patent, then the patent owner hasn't got a very valuable right as an economic matter. The patent's not very valuable. And then the third kind is legal quality. Does this thing that the agency has produced survive judicial review, judicial scrutiny? And sometimes it does, and sometimes it doesn't, and if it doesn't, the reason why can be very important. Is it because the patent office made a mistake? They should not have granted this, and they did. They made an error that now needs to be corrected. That's one type of legal quality problem. Another is that the law changed. At the time that this patent was being examined, the examiner did everything that she was supposed to do, but now the Supreme Court has come down with a decision that says, oh, the law was actually this all along. But this technological, economic, and legal quality framework is a useful way to think about what makes a good patent. And if it fails on any one of those metrics or multiple of them, then that's a bad patent.